pre-lunch, I had sought your Lordship's permission to leave a little earlier. It appears, Wallace, that now collectively we are seeking permission to leave earlier after the very sumptuous lunch which the
Lord,
Advocate General has given to both
my Lord,
sides.
has
So he has
been so
conspired to
hospitable
disable us.
that now it's not possible to sit here to listen to others also.
So he has conspired to disable us, so we may be seeking time early to go. That's all.
okay.
If your Lordship permits our absence,
Whenever you want to leave, you can leave, sir.
we can, my Lord. So that we
Submissions
can-
are over, right?
Our submissions
Yes,
are over.
no problem.
Date for two.
Others are there, I'll hear. And I think a date for the rejoinder,
Yes.
whatever. That should be fine. Yes.
Oblige.
Lordship's kind permission. Like 230 matter is not listed.
2:30.
This matter will continue. Then we'll have
Wait. ಅಲ್ಲ ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ ಅಷ್ಟೇ 1 hour ಆಮೇಲೆ ವಿಲ್ ಟೇಕ್ ಇಟ್
ಆಗ್ಬೇಕು.
I'll finish then thereafter.
There is this written note what I have prepared. I just the questions of law, which I wanted to address, almost all has been substantially covered by the learned Solicitor General. He has effectively at length dealt with each of the issues. If Lordships are to kindly see the written note, almost all the questions.
You only want one thing.
Yes.
All of you have argued many things.
Yes.
What is the role of the Chief Minister? Nobody has said.
In this matter,
Ah,
yes, yes.
it is his sanction.
Correct.
Something should be answered that, but towards
Yes.
that also.
Certainly.
Nothing to answer.
Nothing to answer?
Well, there's nothing. That's why we will justify that.
The role of the Chief Minister shall.
All right.
Yes. But if Lordships are to see Roman numeral 1, the questions which we have framed in the written note which has been given.
And is he telling this post-lunch? Yes. Yes.
Yes. The course of action, not the competent authority, that is the Honorable Governor, was to adopt.
No, I'm only on 17A.
Yes.
17A says
It is 17A.
recommendation, decision taken.
True.
This,
True.
that's all I'm.
I'll cover that issue as
Yes,
well.
yes.
Lordships may kindly permit me to read these questions.
Hmm.
But for in all probabilities, I may not repeat what the
True.
Solicitor General has already
Yes.
done.
Yes, yes.
Maybe a couple of inputs from the own perspective, I'll just put it across. Kindly see the questions, but I'll just quickly read it out so that Lordships will know what are the issues involved. The first question is about the course of action the Governor must take when he receives a complaint against the Chief Minister. Then the question they have raised about the aid and advice, whether he is expected to consider the same. Then about the issuance of notice to the public servant concerned. Third one is about non-application of mind. And whether the fourth one is whether it could have been at the instance of the police officer concerned alone, or whether a private citizen also could have initiated these proceedings. But on the question of aid and advice, Lordships themselves remarked during the course of the hearing that they're having decisions
No, aid and advice.
to that effect. Not only one aspect I just wanted to highlight. But in fact, MP Special Police Establishment case was not a case of the Chief Minister. It was a case of former ministers, wherein, my lords, R.S. Nayak versus A.R. Antule was cited.
Yes.
It is the first of the decision, what the R.S. Nayak versus A.R. Antule. The question was, where, my lord, there, my lord, interestingly, the learned Advocate General had conceded before the Bombay High Court that aid and advice is not required.
That's at paragraph 10 of the
Yes, then,
1992
my lord, their
judgment.
lordship said that concession was rightly made. And, my lords, they thereon not gone to say, but this is what the word, what I wanted to emphasize. There is no doubt that there is a conflict of interest in the Council of Ministers. Therefore, my lord, two situations arise. One is the Council of Ministers can say, we disable ourselves from giving an advice in this matter to the governor on account of the fact that there is likelihood of a conflict of interest. This is what the Honorable Supreme Court says. There are two scenarios. Either when the Council of Ministers disable themselves, the second one is interesting, not they use the word, they become disentitled to aid and advise the government. But may I just
Yes.
emphasize lordships on that
Yes.
particular word what they use there in the
That's paragraph 10 of the
yes,
judgment.
but I am referring to MP Special
MP
Police
special,
Establishment
yes.
where
All right.
they extract R.S. Nayak. May I request lordships to kindly see para 23, what's in that? But this is in the petitioner's compilation of judgments at page 258.
Yes, sir.
Please. The word, lords, apparent bias versus a likelihood of a bias has been emphasized after quoting R.S. Nayak at lords para 13, lord, lordships may kindly peruse that.
Yes.
Mr.
And that-
Sorabji also points out, lord, that is the commences from that sentence.
Yes, sir.
Now, lord, may I request lordships to kindly see the next page at page 261.
261.
261 of that compilation. Well, I'm sorry.
Well, I am holding your compilation here.
We have also given MP special policy.
If you're
Then-
citing MP special
Yes,
establishment.
yes, lord, that's.
That's paragraph
Lordships may
19
kindly
next.
see then paragraph,
19.
please. Paragraph 13,
13, yes, first.
please.
Next 19.
In 13, lords, just one sentence I want to
Yes.
emphasize. Lordships get that the statement,
Yes.
para 11, lord, extract of R.S. Nayak in MP, para 11. The question then is whether we should permit the state of Maharashtra to resile from the concession made before the High Court and raise before us the contention now advanced by the learned Attorney General. We have not the slightest doubt that the cause of justice would in no way be advanced by permitting the state of Maharashtra to now resile from the concession and agitate the question posed by the learned Attorney General. On the other hand, we are satisfied, lots of get that,
Yes.
that the concession was made to advance the cause of justice, as it was rightly thought that in deciding to sanction or not to sanction the prosecution, but this is the telling statement by the Honorable Supreme Court, not to sanction the prosecution of a chief minister, the governor would act in the exercise of his discretion and not with the aid and advice of the Council of Ministers. The application for grant of special leave is therefore dismissed. Then, Lord Lordships may kindly see paragraph 23,
23, 24, 26.
23, Lord, may I? 23, Mr. Tanka
Yes.
is not right when he submits that the governor would be sitting in appeal over the decision of the Council of Ministers. However, as stated above, unless a situation arises as a result whereof the Council of Ministers disables or disentitles itself. The governor in such matters may not have any role to play. Taking a cue from Antule, it is possible to contend that a Council of Ministers may not take a fair and impartial decision when the Chief Minister or other members of the Council face prosecution. But the doctrine of apparent bias, however, may not be applicable in a case where a collective decision is required to be taken under statute in relation to former ministers. That is the distinction what they have made about former ministers, chief ministers, and sitting ministers.
Ultimately, 33 is what is important.
Therefore, they hold, of course, not there. They found the persons against whom this sanction was what had by that time ceased to be the ministers, and the cabinet did not have them as part of the decision. Therefore, they said that the theory of apparent bias will not apply. Likelihood of a bias is likely to be, but then
Reasonable
they
maths
found that
theory.
it was
What
not
the reasonable
applicable.
man would think, that's the theory.
My submission, limited submission before your lordship, therefore, is the Council of Ministers, by virtue of the fact that they become interested in the matter, disentitle themselves from any aid and advice to the Council of Ministers. But quickly about the Honorable Chief Minister remaining outside the meeting, therefore, the Deputy Chief Minister presiding over them, I must say that very judgment, interestingly, they quote A.K. Kraipak. But A.K. Kraipak, lordships are aware that Nashband, interestingly, was the chairman of the selection board and had also participated in the selection process.
Apparent bias.
There, my lord, interestingly, Nashband did not participate in the proceedings. May I just request lordships to kindly see the same judgment once again. MP Special Police Establishment, their lordships note this and say still the theory of apparent bias will continue to apply. That Nashband's act, lords, at para 16. This is para 16, they extract para 15.
Yes.
But their lordships, the sentence commencing from, it is true that ordinarily the chief conservator of all that lordships may not refer to. Kindly see from the word. But under the circumstances, it was improper to have included Naqshband as a member of the selection body. He was one of the persons to be considered for selection. It is against all canons of justice to make a man judge his own cause. It is true, lordships may kindly note, it is true that he did not participate in the deliberations of the committee when his name was considered. But then the very fact that he was a member of the selection board must have had its own impact on the decision of the selection.
Yes, the words, his bias is likely to operate in a subtle manner.
And therefore, the presence of the chief minister in this case and there must be felt an omnipresent presence, brooding presence, we say, in the hall, wherever this meeting took place. But on this question, lordships will also kindly see Article 163 does not bifurcate between Council of Ministers and the Chief Minister. Article 163, in fact, says there shall be a Council of Ministers headed by the Chief Minister. And in the theory of collective responsibility, etc., lordships are aware of those. The question of Chief Minister bifurcating himself from the decision of the Council of Ministers does not arise. Therefore, on looking at this aspect, the question of the governor consulting or looking into the aid and advice of the Council of Ministers does not arise. But on the question of the second aspect, lordships will kindly see about principles of natural justice, 17A.
Yes, sir.
But there is, of course, before I advert to this, they have cited several judgments, including Shamsher Singh, R.A. Mehta, to say that governor cannot act in his individual discretion, etc., including Nabam Rebi. Of course, all these decisions which their lordships have laid down were in different contexts. For instance, in Shamsher Singh's case, subordinate judicial officer was dismissed by the minister concerned without reference to the governor. They were asked to reconsider Sardari Lal's case, where for the first time Sardari Lal's case held satisfaction of the president or the governor means the governor himself and not that of the council of ministers. Therefore, authoritatively they held satisfaction of the president under Article 74 or of the governor under Article 163 must be construed in a democratic polity like ours is to be that of the satisfaction of the council of ministers. Therefore, the principles of Shamsher Singh was different. In R.A. Mehta's case, the appointment of Lokayukta was in interpretation of the Gujarat Lokayukta Act, where the chief minister's primacy is there. Of course, now the law stands settled from a decision arising from this honorable court, Justice Chandrasekhar versus Siddaramaiah, where their lordships tell it is the primacy of the opinion of the chief minister which will prevail. Third decision, these are the three decisions which they have cited, is Nabam Rebia. There again, Article 174. The power of the governor to call for a session prorogate. And in the factual situation of that, they said that no, it could not have been done in individual discretion. Two decisions of the Honorable Supreme Court, similar fact situation as to when the chief minister's complaint or allegation against the chief minister comes, the governor is bound to act independently. Therefore, the decisions may have to be discerned, distinguished in this manner. But on the question of 17A, 17A on a plain reading does not contemplate a notice to the public servant concerned. But whether we can read into that as an opportunity to be given to the public servant concerned before the competent authority arrives at a decision. But I would request lordships to kindly permit me to refer to Subramaniam Swamy versus Director CBI. So it is not that these provisions like 17A or novel. Lordships are aware in number of enactments, permission to investigate a threshold bar is always there. One of them was Section 6C of the Delhi Special Police Establishment Act, which their lordships, in this Subramaniam Swamy's case, struck down. But one of the arguments advanced by Mr. Anil Diwan in that matter, I propose to draw that, wherein he says, if you allow this notice to be given to the public servants, etc., concerned at this stage, it would certainly leave the situation for tampering of evidence, etc. Now, may I request lordships to kindly see that judgment? Yes,
Para 14. Sir.
Yes, para 14. I'll read for my satisfaction. That, of course, I must bring to lordships' notice that paragraph, though he advanced that argument, their lordships, of course, struck it down on the ground of Article 14. You can't
It was on a different
bifurcate corrupt officers into joint secretary and above and below. Their lordships held it in that manner. Para 14, I'll just read.
Yes.
Anil B. Diwan, learned amicus curiae, wants us to take judicial notice of the fact that the high-level bureaucratic corruption goes hand in hand on many occasions with political corruption at the highest level. This very group of high-ranking bureaucrats whose misconduct and criminality, if any, requires to be first inquired into and thereafter investigated, can thwart, defeat, and impair this exercise. In substance, the potential accused would decide whether or not their conduct should be inquired into. He argues the essence of skillful and effective police investigation is by collection of evidence and material secretly without leakage to the destruction or tampering of evidence and witnesses. Such investigation is compromised by the impugned provisions, namely Section 6A of the DSP Act. But the next sentence, the requirement of previous approval in the impugned provision would mean leakages as well as breach of confidentiality and would be wholly destructive of an efficient investigation.
Yes.
Therefore, my lord, if the argument of the other side is to be accepted, let us take a case where there is an allegation that a document has been forged by the public servant concerned, or any number of illustrations could be given. And the police officer who receives this credible information, or a private citizen who comes to know of it, goes to the competent authority and says, "Sir, I have come to know about a particular delinquency of a public servant concerned. I want immediate investigation to be initiated. Maybe he be apprehended, search be conducted, these material objects be, the incriminating material be seized." Would stand defeated, my lords, if notice is to be given to the delinquent employee or the public servant concerned. But this is one way of looking at it. And I draw the argument of Mr. Diwan when he argued the DSP Act for the purposes to say that 17A expressly, consciously excludes notice. One more perspective about this would be, lordships are aware, these 17A and 19 came to be amended, but in 2018. For the first time in 2018, when a private citizen files a complaint under section 19, notice to the public servant is contemplated. Lordships have seen that 19. Lordships are aware that when a private citizen comes to him, the steps are that he goes before the magistrate. Magistrate finds some prima facie case, refers him to go to the competent authority to obtain sanction. He goes back to the competent authority, and then competent authority is obliged to issue notice to the public servant concerned. That is the provision. But the submission which I propose to make before your lordships is, in one stroke, in one legislation, if the legislature has thought it fit to prescribe two different procedures in respect of sanction. One is, of course, a sanction, another is a pre-approval. In respect of sanction by a private citizen, it says that notice is required. In the same amendment, when they introduce 17A, the concept of notice is very conspicuously, consciously silent. The construction of a statute, according to me, therefore, it cannot be stretched to say that the legislature was not aware that when 19 we provided a opportunity to be heard, 17 we do not provide.
19 operates in a different circumstance.
All the time.
Post-investigation.
No, all the time I am submitting before your lordship. The concept of hearing. The concept of hearing is afforded in 19. 17A, it is not done so very consciously. In fact, I am submitting when the legislature by the same amendment provides two different procedures. Therefore, this aspect that the prior opportunity should have been given does not merit. But there are three judgments. One, of course, the learned Solicitor General has read. That is, that is, lordships will kindly, only one judgment I want to refer to on the question of principles of natural justice in criminal proceedings. That Devanand Singh versus State.
Devendra Singh.
Devendra Singh versus State.
Devendra Nath Singh.
Yeah, that's the first one, Devendra. May I request lordships to kindly see that page 52.
Para 52.
No, para 52, not page 79.
Yes. What is audio alterum partem in criminal laws?
Lordships get that. Para 50.
Yes, Chadda's case is quoted.
Yes, Vin Chadda's case.
Vin Chadda's case is quoted. Principles of audio alterum partem as held in Vin Chadda is accepted and said.
They said, therefore, that paragraph, I just wanted to bring to lordships notice this paragraph. Where they quote Vin Chadda, saying, for the present purpose, this is the declaration by their lordships there.
Yes.
Suffice it to notice that as regards the process and manner of investigation, which included the issue relating to the letter report, the court inter alia pointed out The exclusion of the principle of audio alternate partes in relation to an accused at the stage of investigation, the following. I will not that para 81.
There, the apex court holds, the earlier persons were not investigated into. When you want them to come to investigation later, at a
True.
later stage, you should have given them an opportunity, but not in all cases.
In all
what
cases,
is-
one of the arguments they said that different stages the police should have.
Their circumstance was different.
No, but they they import this concept of audio alternate partem and say that in all cases,
Yes.
in all cases, this principle straitjacket formula cannot be used as a straitjacket formula. Is all that what
See para 53, next para.
Please.
In fact, it was said that opportunity ought to have been given.
in the peculiar circumstances.
That's what,
That's
peculiar
correct.
circumstances.
Where investigation was being ordered against persons
Yes,
who were not investigated.
investigated.
That's correct. 173 subsection 8, the further inquiry. But Subramaniam Swami, both the Learned Solicitor
They've
General
already-
and
they've already relied on.
Mr. Maninder Singh, para 44, only one sentence of that 44 words, interpreting the same argument there. Whatever the argument which was advanced by Leonard's friend, 19 unamended stood silent on the question of opportunity. They said opportunity should be given. But even at post-investigation, they said no, it's not possible. They also say that it is the matter of sanction is administrative in nature. It is not quasi-judicial. That is one principle. Second principle is question of notice does not arise. So they will not refuse to read into the principles of natural justice in the unamended 19. It's exactly the argument today before your elections. Therefore, the concept of issuance of notice does not arise at all, and it would in fact cause prejudice to the sanctity of investigation is my respectful submission to Lord.
Yes.
The last limb of this would be whether the public servant concerned at the stage of 17A will have any enforceable right, or the right of hearing would depend on the kind of right which subsists in any provision. But my submission before your lordships is when a complaint or an allegation comes before the competent authority seeking permission to investigate, there is no right as such vested with the public servant at that stage.
Yes.
There is no right vested with the public servant at that stage. In fact, my lord, he is a person who cannot participate in the proceedings at all. It is for the competent authority to decide whether my lord's permission should be given or not. Even at the next stage, if assuming the matter is to go before the station of officer for registration of a cognizable offense, even there he does not have a role until, my lords, a first information report is lodged and he is shown as an accused, but which the Honorable Supreme Court in number of decisions says if a first information report is registered by a station house officer where no cognizable offense is made out on the basis of the averments which are available, he gets a right to move your lordships under 482, etc. So the right to an accused, when he is made an accused, at that stage commences. At the stage when 17A is invoked, he does not have any right. Therefore, the question of hearing does not arise is what I would submit. But the third limb would question would be as to whether the order of the governor stands vitiated on account of non-application of mind. That has been argued at length. Learned Solicitor General has shown before your lordship the original papers itself. I have had the benefit of hearing him, though I did not have the access to records. But what we could make out is elaborate consideration has been made by the governor and to reach to the conclusion that pre-approval is required. Only two aspects from the order of the governor I propose to highlight before. Two developments which the Honorable Governor takes into account is two orders passed by the government themselves. One is the order constituting a 4-member committee headed by one Sri Venkatachalapati for investigating into the matter. Second is, my lords, the constitution of a single judge commission of inquiry.
P.N.
Under the
Desai.
commission of inquiry
Justice
Act.
P.N. Desai.
For the purposes of looking into this matter. But may I now request lordships to kindly see the terms of reference and the nature of the order while constituting these two orders. But they have produced it along with the writ petition. My lords may kindly see volume 2 of the writ petition at page 591.
$592.
591 is that first Venkatachalapati report.
Yes.
At 592, my lords, when they say 1/7/2020 for other ಮೇಲ್ಗಡೆ paragraph.
All right.
May I just read that paragraph? ವಿಶ್ವವಾಣಿ ಪತ್ರಿಕೆ ವರದಿಯಲ್ಲಿ ಪರಿಶೀಲಿಸಲಾಗಿ ಮೈಸೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದಲ್ಲಿ ನಿವೇಶನ ಹಂಚಿಕೆಯಲ್ಲಿ ನಿಯಮ ಬಾಹಿರವಾಗಿ ನಿವೇಶನ ಹಂಚುವ ಮೂಲಕ ಹಗರಣ ನಡೆದಿರುವುದು, ಇದರಿಂದ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಅಪಾರ ನಷ್ಟ ಉಂಟಾಗಿರುವುದು, ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆಗಳಿಂದ ಹಾಗೂ ಸಾರ್ವಜನಿಕರಿಂದ ಹಾಗೂ ಜನಪ್ರತಿನಿಧಿಗಳಿಂದ ಬರುತ್ತಿರುವ ಅನೇಕ ದೂರುಗಳಿಂದ ನಿಯಮ ಬಾಹಿರ ಕ್ರಮ ವಹಿಸಿರುವುದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬರುತ್ತಿದೆ. ಇದರ ಸತ್ಯ ಅಸತ್ಯವನ್ನು ಅರಿಯಲು ಒಂದು ತನಿಖಾ ತಂಡವನ್ನು ನೇಮಿಸುವುದು ಸೂಕ್ತವೆಂದು ತೀರ್ಮಾನಿಸಲಾಗಿದೆ. ಅದರಂತೆ ಕೇಳ್ಕೊಂಡು. Now, lordships may kindly see the terms of reference to the under the Commission of Inquiry Act at page 594. Almost, lords, there are about 7-8 questions they have framed. Almost every question refers to illegality of allotment of sites, illegality of the method and manner in which MUDA acted in giving these sites, including as to whether persons had benefited themselves, though they were not entitled to so. But may I request lordships to kindly see terms of reference 6, 7, and 8. ಕಾನೂನು ಬಾಹಿರವಾಗಿ ಪರಿಹಾರದ ರೂಪದಲ್ಲಿ ನಿವೇಶನ ಜಮೀನನ್ನು ನೀಡಿದ್ದಲ್ಲಿ ಅದನ್ನು ಗುರುತಿಸಿ ಸೂಕ್ತವಾದ ಕ್ರಮವನ್ನು ಜರುಗಿಸಲು ಸಲಹೆಯನ್ನು ನೀಡುವುದು. 7. ಕಾನೂನಿನಲ್ಲಿ ಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆಗಳಿಂದ ಮೂಡಾ ಸಂಸ್ಥೆಯು ವಶಪಡಿಸಿಕೊಂಡ ಜಮೀನುಗಳ ಸಂಬಂಧಿಸಿದಂತೆ ಪರಿಹಾರದ ಬದಲಾಗಿ ನಿವೇಶನಗಳನ್ನು ಮಂಜೂರು ಮಾಡಲು ಮೂಡಾ ಸಂಸ್ಥೆಯ ವಿವಿಧ ನಿರ್ಣಯಗಳನ್ನು ಕಾನೂನುಬದ್ಧವಾಗಿದೆಯಾ ಮತ್ತು ಬಂಧನಕಾರವಾಗಿದೆಯೋ, ಪ್ರಾಧಿಕಾರದ ವತಿಯಿಂದ ಸದರಿ ಅವಧಿಯಲ್ಲಿ ಹಂಚಿಕೆ ಮಾಡುವ ಸಿಎ ನಿವೇಶನಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಡೆದಿರುವ ಅಕ್ರಮಗಳ ಬಗ್ಗೆ ವಿಚಾರಣೆಗೊಳಿಸುತ್ತೇವೆ. ಅಂಡ್ ಇನ್ ದ ಪ್ರೀವಿಯಸ್ ಆರ್ಡರ್ ದೇ ದೆಮ್ಸೆಲ್ಫ್ ಸೇ ಮೇಲ್ನೋಟಕ್ಕೆ ಸಾಬೀತಾಗಿದೆ ಅಂತ. Prima facie, there is illegality in so far as the entire, let's say, I would not say scam, but entire allegations which have been made. And these are the present complaint on which the governor acted upon, or what was before him, lords, was the same one. But the governor therefore records, if the government is satisfied that the allegations require an investigation, albeit by a retired judge under the Commission of Inquiry Act and by a committee of IAS officers, the principal, lord, then he takes it slightly higher. He says, when a person is accused or lord, there is an allegation against him, the investigations shall not be at his instance or by his choice. This is one of the reasoning, lord, the Honorable Governor takes. Therefore, he uses the word non-partisan investigation is required into the matter, and these Commission of Inquiry etc. do not inspire confidence. This is how, lords, my respectful submission to lordships would be that when these considerations are taken into account, apart from, lord, the elaborate notings which they have submitted before your lordships, it cannot be said that there is non-application of it. No, it is one thing to say the governor should not have acted in this manner or not. But it cannot be said that there is non-application of the mind. But he has applied his mind. He has perused these orders and seen that there is a requirement of an investigation even according to the government. But then about the difference between what's approval and sanction. Sri Rupa, the learned Solicitor General has read their paragraph in that written note itself,
Yes,
I've
yes.
given at page 5, para 34, 35, 36, 37.
Yes.
But there is one decision of the Delhi High Court on this
17A.
17A. But that in that compilation itself, Lordships. AP Patak versus CBI. That is at page 167 onwards. But there para 9, 10, 11. They were, but this is, I'm sorry, this is about 6A of the Delhi Special Police Establishment Act. That question of consent, similar situation. That consent, before investigation. Para 9, Lordships Mechanics.
Yes.
In Mayavati, Honorable Supreme Court was dealing with the case of consent from the state government for the registration of FIR and to investigate the matter. In the absence of which the CBI had no jurisdiction to register the FIR.
No, there is consent
Five,
under the
no, but
Delhi
these-
Special
no,
Police.
these- no, they have interchangeably used the word. Kindly see para 10. There is an obvious distinction between approval, consent, and sanction. Therefore, they club approval and consent as one category and sanction of the other. An approval or consent implies mere concurrence or agreement, whereas sanction confers an authority on the person in whose favor power to grant sanctions conferred. The difference between approval, consent, and sanction is that of a degree in state of Maharashtra versus Janardhan Ramachandran Navalkar. Their lordships have examined that, and kindly permit me to read that paragraph, where they refer to Prevention of Food Adulteration Act, similar provision for consent. Besides, it must be remembered that under Section 20 of the Prevention of Food Adulteration Act only, consent of the commissioner is necessary and not sanction. There is obvious difference between consent and sanction. Consent implies mere concurrence or agreement, whereas sanction confers authority on the person in whose favor sanction is granted. Therefore, considerations applicable in the case of sanction would, in my opinion, not be applicable to case where mere consent is required. Therefore, this is what in Sri Rupa's case, what the coordinate bench says, it is much narrower. The approval has to be very brief. And as the Solicitor General rightly put it across, particularly when it is being exercised by possibly the highest constitutional authority. He does not want to prejudge the entire issue so that it would influence the investigating authority, whatever it is. That is the difference I wanted to bring to Lordship's notice between 19 and 17A. As regards as to whether 17A could be at the instance of the police officer concerned alone, Lordship's decision in Ashoka versus State of Karnataka, in fact, takes that into consideration. Para 534 Lordships are aware of that, where Lordships, in fact, considered this aspect and held that if a private citizen wants to move the court, he has to obtain pre-approval, necessarily implying that he can also move 17A before the competent authority. Then Subramaniam Swami's case relies upon that. Just two or three aspects I wanted to bring to Lordships. One of the arguments which was advanced before your Lordships is that the order of the governor must be tested on witness principles, etc. Just like any other administrative order. And therefore, if it is found that he did not address himself to the questions which really arose, it must be struck down. That was the line of the argument. But I was wondering whether when a governor passes an order, but notwithstanding the fact that he's answerable, in a way not answerable to the court, but if an order of his is impugned before your Lordship, what should be the approach of judicial review? But one sentence in Bommai's case, though my lord, their Lordships were examining decision under Article 356, maybe my lord throw some light. May I request Lordships to kindly see Bommai, my lord, they have cited. I'll just bring to Lordship. They have cited Bommai at Lords at page 310. But I am very conscious when I read this, that this was a case where 356.
Article 356.
But Lord, kindly look at the way Lord, their lordships describe the role of the governor when he exercises his power under the Constitution. Article 163, Madam, page 639.
We'll go to para 282.
But I am referring to para 373 first. Lordships get para 373.
Yes.
In 373, if my lords are to see the sentence commencing from, this is not true of our constitution, it says.
Yes.
Lordships get, this is not true of our, para 370. Same copy. But 373 commences from the sentence whenever proclamation.
Yes.
They, they're somewhere in the middle, Lordships get that government of Malaysia, they have referred to 58.2.
Yes.
Then, the sentence commencing from that is not true of our constitution.
Yes.
That is not true of our constitution. Hence, the president acts on the aid and advice of the Union Council of Ministers and not in his personal capacity. Moreover, there is a check of approval by Parliament which contains members from that state against the government legislative assembly of which state action is taken as well. So far as the approach adopted by this court in barium chemicals is concerned, that is not classical administrative order, how to test, that's how not they'd argue. But kindly, it is a decision concerning subjective satisfaction of an authority created by a statute. The principles evolved then cannot ipso facto be extended to the exercise of a constitutional power under Article 356. The next sentence is what I would request lordships to kindly consider. Having regard to the fact that this is a high constitutional power exercised by the highest constitutional functionary of the nation. Obviously, they were referring to the president.
There the president.
It may not be appropriate to adopt the tests applicable in the case of action taken by statutory or administrative authorities, nor at any rate in their entirety. We would rather adopt the formulation evolved by this court in state of Rajasthan, as we shall presently elaborate. Therefore, my lords, having regard to the fact that the order comes from the governor, who, my lord, under the scheme of the constitution, is the highest constitutional authority. The principles of judicial review sometimes, my lords, may have to vary, is my submission before your lordships, insofar that is concerned. But since I am referring to Bommai, my lord, I would also request lordships to kindly see paragraph
320.
Paragraph 3. Let's paragraph 282. 82. In that, they use these are all very real exposition of the constitution by the lordships. When they use this sentence, I must state when remarks are made about the governor, kindly look at the sentence where the lordships say.
Yes, sir.
In fact, it would be a case of his reporting against his own government, but this may be a case of wearing two hats. Not when he recommends for wearing two hats. One as the head of the state government and the other as a holder of an independent constitutional office whose duty is to preserve, protect, and defend the constitution. But it is one thing to say the governor is bound to do whatever we say. It's another thing to also see that he also holds an independent constitutional office whose preeminent duty is to protect and defend the constitution.
Yes.
But in Bommai again, because they have relied upon the aid and advice of the Council of Ministers.
That is at 320.
Yeah, 320. But in fact, Article 163 subclause 3, what says as to what was the aid and advice given by the Council of Ministers to the governor will not be called into question in any court. Rather, the court will not inquire into it. That,
Slight dilution later.
that was, when it was cited, what their lordships held is, what happens between the president and the council of ministers, we are not concerned. Ultimately, what is the decision the president makes is what we will look into it for the purposes of arriving at a decision. That is what I wanted to submit, these last four of them. I will address the last question lordships asked about the role of the chief minister. I'll have to answer that. Before that, two other things I must bring to lordships notice. Is one other decision, lords, of course, not for any other purpose. The Terrorist and Disruptive Act, TADA, also contains some sort of a filter like this, wherein lords, prior concurrence of the authority is required before initiation of investigation. So interpreting those provisions, in Satyan, one of the lordships may kindly see in that compilation at serial number 7, State of AP versus A. Satyanarayana. That commences at page 181. But I am citing this judgment for this proposition, and I'll bring to lordship's notice as to why this becomes relevant. At page 181, let's get it, paragraph 8. But there is section 20 capital A of the TADA, which provides for a prior permission. But they go to the extent of saying prior approval. Their lordships go to the extent of saying in para A, even an oral approval is sufficient. But the emphasis which I am saying is not in. I was bringing to lordships notice, this is not the first of its kind where prior approval is recommended. Number of central enactments and some state enactments as well as have this prior approval before investigation is done. Interpreting most of these provisions, their lordships hold, that is, it is not something very formal. It is not something which is elaborate. It is something which has to be more informal, considering the prima facie satisfaction of the authority concerned. In Satyanarayana's case, they go to the extent of saying even a oral permission is also sufficient. But this is one aspect. Then, I wanted to bring to lordship's notice about this B.S. Yediyurappa's case they have cited. That is division bench judgment of this court. To say about advice. But I must bring to lordship's notice that that decision, division bench decision, in fact, does not state any law. Does not make any declaration of any law. And certainly cannot be considered as a precedent.
Does not declare any law.
It does not. But I'll bring to lordship's notice why. That is, lordships have the division bench judgment. Yeah, please. Yes. So there, one of the I had some knowledge of how that matter went.
You had appeared.
No, I had not appeared. I was there as additional advocate general that time. I had not appeared. In fact, if I recollect, Mr. Ram Jethmalani had come to argue this case initially, but I think by the time the matter came up for final hearing, he was not there. But there, apart from other things, the Council of Ministers had sent an advice to the governor. But it so happened during the course of the hearing, the governor, forget referring to that advice was also not available in the file. Therefore, their lordship said that advice which the Council of Ministers have supposed to have been given, it is nowhere reflected. Forget considering that. Therefore, we say that that should have been considered. Is all that division bench says. No argument was advanced in the line which has been advanced today before your lordships about either citing Antule or, for that matter, MP State Establishment Act to say that it was. And the governor there, of course, had granted prosecution. Of course, by the time the matter was heard, the petitioner had ceased to be the chief minister, etc. That is therefore that Yediyurappa's case cannot be cited as a precedent. Is my submission before your lordships. Then they have relied upon the standard operating procedure, which they say that
The CBI.
SOP. It is for CBI, and according to me, there is no statutory force to that. There is no statutory force because under the Act, there is no power given to the central government to make any guidelines under 17A. There is no provision. So there cannot be by way of an executive instructions add or subtract or dilute the provisions of 17. Then Lords, the last one Lordship said about recommendation, they have said, what is my recommendation? What is my decision has been answered. But may I request Lordships to kindly see 17A once again. Of course, my lords, it is very tempting for us to, my lord, bring records before your lordship to say what has been the decision, etc. But these are all matters, my lords, which may require investigation. But on a plain reading of 17A, lordships may kindly discern how it comes. It starts by saying no police officer shall conduct any inquiry or investigation.
No,
I'll just
their submission is that
relatable.
have been committed by a public servant under this act, where the alleged offence is relatable to any recommendation made or decision taken
May I
by such
request
public
lordships,
servant
may I request lordships
in discharge of his official
Well,
functions or
but
duties.
lordships may kindly see, there is the first sentence, lordships may kindly permit me to.
Yes, yes.
No police officer shall conduct any inquiry or investigation into any offence. Lordships may kindly see. Lordships may permit me to emphasize, into any offence alleged to have been committed by a public servant
Under
under
this
this act. That is a comma. There is a comma there.
Comma.
There is a comma.
Under this act,
That's true.
any offence
Any offence for that.
under the Prevention of Corruption Act.
That's true.
Yes.
But I will just demonstrate before your
Any
lordship.
offence, it can be any offence under the act.
Yes, comma, then it is followed by where the alleged offence is relatable to
Yes,
any recommendation made or decision taken by such public servant
yes.
in the discharge of his official functions or duties without the previous approval. Now, my lords, the Prevention of Corruption Act starts from 7 to section 7 onwards, refers to several of the offences.
Yes.
All the offences there, my lord, do not per se involve a decision or a recommendation of the public servant. For instance, lordships may
No,
kindly
section 7 is straight away, it is a criminal misconduct by a public servant where he is trapped or accepting money or others.
no, lordships may kindly see
13 is disproportionate.
no, lordships may kindly see section 7C, for instance.
Yes.
If for instance, 7C, lordships may kindly see. Any public servant who
Induces
perform-
another.
No, I am only trying to make this point for you. Let me explain what is that I am trying to say.
So you're trying to bring in the
All
acts,
offences-
acts that are now foundation for the sanction under 7C.
No, I'm not referring to the present facts of the case. It could possible also. It is possible 7C is also invoked. Maybe. I am at this stage. It may not. All that I am bringing to lordship's notice is if a correct reading of 17A is made, it encompasses all offences under the act. Lordships may permit me to state in the same
Yes,
breath.
all offences under.
Need not, therefore they use the word relatable to the recommendation or the decision. For instance, 7C, what 7C makes it an offense if a public servant induces another public servant to do an act for the benefit of himself or any other person.
Yes.
There obviously there is no recommend or decision by him. Lordships may keep this proposition in mind. But would that not take away the filter of 17A? No, obvious answer according to me is no, because it speaks of any offense under that. Therefore, not the word relatable to any decision or a recommendation must be meant to mean any relatable to the offenses right from 17 to 30. It need not be, put it across simply, it need not be that there must be a decision taken by me or a recommendation made by me which is culpable of for any of the offenses commencing from 7 to 30.
Yes.
It could be in a given situation, it may be perfectly open for anybody to argue that recommendation may include oral recommendation as well. But I'm only bringing to lordship ultimately the Honorable Supreme Court as well. This is the Prevention of Corruption Act. The interpretation must be to ensure the laudable objects of the act is fulfilled and not to allow delinquent public servants to get away by such interpretation. My submission before your lordships is that. Therefore, whenever we speak of recommendation or a decision to be made by the public servant concerned, it need not be, I'm not saying but in this case, I'm for a moment not suggesting. It need not be a recommendation or a decision per se, but if any of the offences under 7 to 13 are invoked, it would be certainly the protection of 17A will come. Of course, the alternative argument of Mr. Tushar Mehta that if according to them 17A is not applicable, then it also leads to investigation any other way is something which Lordships will kindly consider. Therefore, my respectful submission to Lordships is that having regard to these aspects, the writ petition at this stage would not call for any interference. That, my lord, the petitioner, I must bring to Lordship's notice, is at a stage where there is a threshold beginning. He would get many more opportunities in case, my lord, anything adverse is taken by either the magistrate before whom the private complaint may go or before the station house officer if a first information is to be lodged. He would get an opportunity in case an adverse, let us say, a first information report is.
So the complaint is already before the sessions court.
It is complaint is before the sessions court, but no orders are passed. But all that I'm saying is
that was awaiting approval.
No, all that I'm saying is it is not that they will not have an opportunity. In case an adverse or if something is to be done there, they will certainly have an opportunity to call into question. Therefore, my respectful submission is that this matter does not call for interference. Of course, I must say, I do not want to use the word profound respect, which Mr. Tushar Mehta gave a different meaning, but having regard to the totality of the circumstances, I did not want to repeat myself as to what Mr. Leonard Solicitor General had dealt with.
Yes.
I'm sorry, Lord, if there has been some repetition.
He's behind the television. I could not see him. Yes. He's TV ಹಿಂದ್ಗಡೆ ಇದ್ರೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಈ ಕಡೆ ಬನ್ನಿ. ನೀವು ರಿಪೀಟ್ ಮಾಡಲ್ಲ ಅಲ್ವಾ?
For the respondent number 3, my lord.
ಗೊತ್ತು, ಅದು ರಿಪೀಟ್ ಮಾಡಿ, ತೊಂದರೆ ಇಲ್ಲ.
No, my lord. There's no repetition of any of the grounds, my lord,
Yes.
which were urged earlier.
R4. 5 ತಾನೇ?
At the outset, my lord, Lord, I was, my lord, in the previous state of hearing, I was assailed primarily on the ground that I had earlier applied for sanction, and now, my lord, in my statement of objections, I have taken the stand that I don't require sanction. Lord, I was assailed on that ground that my approach is uncertain. Now, my lord, Lord, what was the cause of action for me to approach the Honorable Governor seeking sanction? Now, if my lords may kindly take to page 261, my lord, which is nothing but the operative portion of my lord's judgment in Dr. Ashok's case.
Page 261 of what?
Lord, of the writ petition.
ಅದರಲ್ಲಿ ಹಾಕಿದಾರ?
Please. Page 261.
Yes.
Lord, the second paragraph, which my lord had rendered, a private complaint should also append prior approval granted by the competent authority to register a private complaint. I would stop at that, my lord. My lord, the word append, my lord, which is nothing but a synonym of the word attach or add.
Correct.
My lord, now that being the case, my lord, Lord, I would be, my lord, disabled to even, my lord, go before the special judge and place my complaint, my lord, at the hands of the special judge.
Correct.
Because
You had to take approval.
I had to take
Yes.
approval. So that is why, my lord, I had approached the Honorable Governor.
Who is saying that is wrong?
Lord, now it is now that, my lord, I have also, my lord, in my statement of objections, I have contended that I don't need sanction and I have quoted reasons for this.
That's your contention. It's all.
Please, my lord. My lord, the reasons being,
So
my
to
lord,
bring it in tune with Ashok's case, you
please,
you
it was
approach
only-
the governor.
It was only an adherence and respectful compliance. My lord, in fact, when I, my lord, approached the Honorable Governor, the same question, my lord, was posted to me.
Now,
Because,
one clarification.
please,
Before approaching the governor, you had approached the jurisdictional police by registering complaint.
please,
ಅದು ಮಾಡಿದ್ರಾ?
both 154(1) and 154(3)
Both are complied.
Both are complied. Both are complaining.
And
Thereafter, my lord-
ಆಮೇಲೆ 200 was invoked.
no, thereafter governor's sanction was sought for.
Sought for.
Sought.
ಆಮೇಲೆ you filed the
Then, my
complaint.
lord, I have filed a private complaint. Pending approval from the honorable government. My lord, since, my lord, there was a dictum, my lord, which was laid down by my lords in Dr. Ashok's case, I had to, my lord, without choice, approach the honorable government. Since I was disabled, my lord, to even approach the special court. My lord. There was a circular, my lord. A circular, my lord, would signify that it's against the general public as well. So I was bound to comply. My lord, since, my lord, Dr. Ashok's case, my lord, it was not the case at hand when my lordships dealt with Dr. Ashok's case. My lord, Dr. Ashok's case, my lord, with due respect, my lord, to my lord's dictum. My lord, in Dr. Ashok's case, my lord, a situation where a private complaint, my lord, is placed before a special judge, and, my lord, if at all, the very case or the very allegations do not warrant sanction under section 17A, then, my lord, how the special judge must treat the situation.
It
my
was
lord?
not why Ashok was written.
No, it is not, my lord. That is my contention.
In
It is
Ashok's
silent in that
Ashok's
regard.
case, what happened
Please.
was, prior to Ashok, there were 13, 14 cases.
Please, ma'am.
Against public servants, they approached the competent authority seeking approval under 17A.
Absolutely.
It is kept pending or not granted.
Not.
Though there are several
Please.
allegations of which would touch upon cognizable offense or corruption or whatever. Then straight away they used to approach the magistrate. Once the magistrate or the special court refers the matter for investigation, there is no choice but to register an FIR.
Please.
That is why here they don't get the registration of FIR because 17A bar is
Please.
there. They get an FIR straight away there. That is why Ashok was written, that approval there also would be required
Required.
from competent
Yes.
authority. Otherwise, the very section would be rendered negatory. That is the reason that was written. Yes, and that is why you have also applied for
No, my lord.
approval.
My contention is that, my lord, in fact, my lord, looking to the facts of the case, my lord, the allegations specific, not, my lord, warrant seeking sanction for section 17.
Approval. Approval is 17, 218 is sanction.
So 17A, my lord, the expression, my lord, in discharge of official duty or in connection to official
Even 197 also the same thing. 218 is 197, yes.
Now, that very expression, my lord, in connection to the official duty or integrally connected to the official duty. My lord, in the instant case, if I take my lords to the gist of the allegations made in the sanction application. Just to attain little clarity, but although facts
No,
are partly-
extensively, yes.
On 20th/8/1997, there was a final notification.
92 preliminary notification, 97 final notification. Yes, 1997.
And I'm also not on legality of acquisition and.
That's what. It's all right, yes.
Now pursuant to this notification, but the ownership of the land, my lord, ownership and possession of the land stood vested with MUDA.
MUDA.
The revenue records from the year 1998 to 2004, my lord, would clearly denote this. Subsequently, my lord, on 30th March 2004, final award notice, my lord, came to be issued. Final award notice.
2004.
30th March 2004, final award notice came to be issued. Lord, by 15/6/2004, there were, my lord, numerous sites that were formed and also allotted to the respective allottees, which is, my lord, forthcoming from the allotment register put up at
Sites were also allotted.
page 135 and kindly.
Yes.
Kindly page 135 and kindly. This is the allotment.
Yes. 135 of the writ petition.
Typed copy of the allotment.
Yes. ಇವರಿಗೆಲ್ಲ ಅಲಾಟ್ ಮಾಡಿರೋದ ಇದು?
After complete full-fledged layout was
ಮಂಜೂರು ಮಾಡಿ ಕ್ರಯಪತ್ರಗಳನ್ನು ಈಗಾಗಲೇ ನೀಡಲಾಗಿದೆ. ಕ್ರಯಪತ್ರಗಳನ್ನು ನೀಡಲಾಗಿದೆ.
conveyances were
Yes.
But now, my lord, I would travel I would again travel to 1998. Now, this denotification, my lord, was in the name of one Ninga, my lord, Ninga son of Javra. My lord, he was by then, my lord, no more, my lord.
Denotification yavaga?
My lord, 18/5/1998, my lord. 18/5/1998.
Yes. Hmm.
Now, this denotification, interestingly, was 45 days after the issuance of final award notice. This may kindly be noted down. 45 days, exactly 45 days after the issuance of final award notice.
All right.
Now, my lord, it is for the legal heirs of the deceased person, my lord, in whose name the denotification was done, for them to reclaim the physical possession of the land, my lord. My lord, in fact, till date, my lord, till date, there has been no claim over the possession of the land. Till date, it remains the same. From, my lord, the date of denotification. The possession still vests with MUDA. Now, my lord, now coming back to 15/6/2004, my lord.
Hmm.
Lord, there was any more, my lord, the Devanuru third stage, the Kesre Grama, my lord, which is the land in question, survey number 464, Kesre village. Lord, it ceased to exist, my lord, by the year 2004, as per the records. It ceased to exist because Devanuru Padavane came into the place.
Because
Devanuru Padavane came into place, which comprised of full-fledged layout, inclusive of roads, parks, sites, and other civic communities.
all right.
Now, my lord, as produced from the allotment register, my lord, by, my lord, 15/6/2004, there were numerous allottees, my lord, who were allotted these sites.
All right.
My lord, on 25/8/2004, my lord, 25/8/2004, a sale deed, my lord, came to be executed by one Devraju who claims to be the owner of the land.
Of what land?
The same land in question, my lord. Now, here, my lord, although the Devanuru Badavane no more exists,
Huh.
he states that he is the owner of the said land in question, and he executes it. And he executes a sale deed.
That
Although, my lord, Kesare Grama ceased to exist and only Devanuru Badavane is in place. On 25/8/2000.
sale deed refers to Kesare Grama.
Lord?
Sale deed refers to Kesare
Sale
Grama.
deed refers to Kesare Grama. Sale deed refers to Kesare Grama, which
Yes.
is not in existence anymore, man. Now, my lord, in the sale deed, if my lordship may kindly peruse, at page 122, my lord, of the red petition.
Hmm.
I'm sorry, my lord. First, my lordship may kindly peruse page 118, my lord. In the third paragraph, my lord, unnumbered third paragraph, if I may read, my lord.
Schedule nalli namude.
ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ನಮೂದು ಮಾಡಿರುವ ಸ್ವತ್ತು ನಮಗೆ ಪಿತ್ರಾರ್ಜಿತವಾಗಿ ಬಂದಿದ್ದು, ನಮ್ಮಗಳ ಪೈಕಿ 1ನೇ ಜಿ ದೇವರಾಜ ಆದ ನನ್ನ ಹೆಸರಿನಲ್ಲಿ ಖಾತೆ ಹೊಂದಿದ್ದು, ತಹಲ್ವರವರೆಗಿನ ಕಂದಾಯವನ್ನು ಕಟ್ಟಿಕೊಂಡು, ಕೈಂಡ್ಲಿ ಮೈ ಲಾರ್ಡ್, ದಟ್ ಮೇ ಬಿ ಟೇಕನ್ ನೋಟ್ ಆಫ್ ಮೈ ಲಾರ್ಡ್, ಕಂದಾಯವನ್ನು ಕಟ್ಟಿಕೊಂಡು ಆಲಿ ನಮ್ಮ ಸಂಪೂರ್ಣ ಮಾಲೀಕತ್ವ ಮತ್ತು ಹಕ್ಕು ಬಾಧ್ಯತೆಗೆ ಸೇರಿ ಸ್ವಾಧೀನಾನುಭವದಲ್ಲಿ ಇರುವ ಸ್ವತ್ತಾಗಿರುತ್ತದೆ. Now I invite my lordship's kind attention to the schedule, my lord, which is forthcoming at page 122.
Yes.
Here, my lord, another interesting aspect, my lord, which would emerge. If I may read, my lord, the schedule, ಮೈಸೂರು ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿ ಕೆಸರೆ ಗ್ರಾಮಕ್ಕೆ ಸೇರಿದ ಸರ್ವೆ ನಂಬರ್ 464ರಲ್ಲಿರುವ 3 ಎಕರೆ 16 ಗುಂಟೆ ಕುಷ್ಕಿ ಜಮೀನಿಗೆ ಸೇರಿದ ಚೆಕ್ಕು ಬಂದಿ. He makes 3 claims, my lord. He makes 3 claims. One is he is alienating an agricultural land. Second is he has paid tax up till 25/8/2004, which is the date of conveyance, my lord.
But by then sites were formed and allotted also.
That is our case, my lord. There were,
How will it remain agricultural land?
my lord, that is what, my lord, a non-existent land was subjected to a conveyance. It has been. And the third assertion, my lord, that he makes is that he had retained ownership and possession till 25/8/2004.
All right.
My lord, a non-existent land, my lord, was sold. Non-existent land was purchased. Possession, my lord, of the non-existent land was handed over.
Now, who purchases it?
Purchased by Mallikarjunaya, who is none other than the brother-in-law of the petitioner.
All right.
Please. Now, my lord, The next development, my lord, 15/7/2005. 15/7/2005.
15/7.
15/7/2005. I may invite my lordship's kind attention to page number 136, my lord.
Yes.
Lord, this is an order of conversion, my lord.
Version.
Conversion order. My lord. Land, my lord, was fully developed. The Kesre Grama ceased to exist anymore. Now, the same land, my lord,
After this B.M. Mallikarjuna Swami
after
purchased it.
Mallikarjuna Swami applies for conversion. He applies for conversion.
Yes.
By order dated 15/7/2005, my lord, an application for conversion of a non-existing agricultural land was, my lord, filed by Mallikarjuna Swami. And by order dated 15/7/2005, my lord, the then DC, my lord, one Selva Kumar.
All right, it is, conversion is granted.
Conversion is granted, interestingly, based on two field inspection reports, my lord.
Based on inspection reports.
Based on spot inspection report, please, my lord. By both by the Tahsildar and DC, my lord. Now, my lords may kindly peruse page 138, my lord. 138. My lord, this is the spot inspection report of the Tahsildar. If I may read the topmost portion, my lord. ದಿನಾಂಕ 4/3/2005 ಕಸಬಾ ಹೋಬಳಿ ಕೆಸರೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 464 3 ಎಕರೆ 16 ಗುಂಟೆ ಜಮೀನಿನ ವಸತಿ ಉದ್ದೇಶಕ್ಕಾಗಿ ಶ್ರೀ BM ಮಲ್ಲಿಕಾರ್ಜುನ ಸ್ವಾಮಿ ಎಂಬುವವರು ಭೂ ಪರಿವರ್ತನಾ ಮಂಜೂರಾತಿ ಕೋರಿರುವ ಜಮೀನನ್ನು ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ಕಸಬಾ ಹಾಗೂ ಗ್ರಾಮ ಲೆಕ್ಕಿಗರೊಡನೆ ಸರ್ವೇಯರ್ ಜೊತೆಗೆ ಸ್ಥಳ ತನಿಖೆ ಮಾಡಿರುತ್ತದೆ. Subsequently, my lord, another report, my lord, where the DC gives a report stating that he has visited this spot, which is forthcoming at page 139, my lord. Please.
DC also.
DC also, my lord. In fact, if I may quote, my lord, the DC one, Shri Kumar Nayak, is, my lord, presently the MP of Raichur district. Just for intimation, my lord, nothing more than that. He also, my lord, he says that he has visited this
What
spot.
has that got to do? Yes. All right.
Now, my lord, I would once again, my lord, draw my lordship's kind attention to page 136. Once again, my lord. Please. The third paragraph, my lord, unnumbered third paragraph.
ಅರ್ಜಿದಾರರಿಗೆ ಅದ?
No, no. ಮೈಸೂರು ನಗರಾಭಿವೃದ್ಧಿ
ಪ್ರಾಧಿಕಾರ.
Please. ಮೈಸೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದ ವಿಶೇಷ ಭೂ ಸ್ವಾಧೀನಾಧಿಕಾರಿಗಳ ಪತ್ರ ಸೋ ಅಂಡ್ ಸೋ ದಿನಾಂಕ 3/9/98 ಪ್ರಸ್ತಾಪಿತ ಜಮೀನನ್ನು ಪ್ರಾಧಿಕಾರವು ಭೂ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳಲು ಈವರೆಗೂ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿರುವುದಿಲ್ಲ. Lord, the notifications are before my lords. Now, the sanction is granted based on the ground that the land was never subjected to conversion. And, my lord, which lands, my lord?
The very same 3.16 acres.
Very simple. Kindly, it may be perused, my lord. The survey number, the village name, everything is identical, my lord.
All right. Next.
My lord, which lands, my lord, did the revenue officials visit, my lord? Probably my learned senior friend was referring to Wonderland, my lord. Alice in the Wonderland. But here, there is Mallikarjuna Swami, my lord. No Alice. But Wonderland exists. No, my lord. A conversion, my lord.
Land is converted.
Land is converted. Non-existing land is converted.
All right.
Lord, now, my lord, my lordship pointed out before my learned senior started, what is the role of the chief minister? Lord, see, petitioner, my lord, wants this court to believe that these, my lord, blatant illegalities were committed by the offences on their own volition or their own will and fancy. Is it, my lord, possible? Now, I would, my lord, take my lords to further developments. Subsequently, my lord, now we would travel to 2010, my lord, from 2005 conversion.
Then page 140 is
My lord, this is a gift deed. Gift deed.
gift deed from?
Gift deed. From Mallikarjuna Swami to his sister, who is none other than the wife of the petitioner.
This very land, 3.16 acres.
3.16 acres. My lord,
But
page
where is the
140.
land?
There is no land. That is our case, my lord. Non-existent land has been subjected to multiple conveyances. Non-existent land has been subjected to conversion. That too upon spot inspection of the Tahsildar
No,
and the.
You only told me that 97 final notification,
Please,
33 final award notice.
please.
Then 15/6/2004 land is formed, sites are formed and allotted to everybody.
Please.
After that, all these things have happened.
After that, all these things have happened.
All right.
My lord, how could the revenue authorities, my lord, find and identify an agricultural land, my lord, to pass an order of conversion? But these are the shocking facts, my lord, which emerge, my lord. Once we go further, my lord, there are even more.
Okay.
Please, now I would take my lords to the gift deed. My lord.
Hmm.
Gift deed, my lord, was made by my lord one Mallikarjuna Swami, who is none other than the brother of the brother-in-law of the
Gift deed is in accordance with law.
No, my lord. How can it be, my lord? Non-existent land is gifted.
Lala, he has purchased some land, got
Yes.
it converted.
Got it.
He has gifted it.
My lord, where was the land to purchase?
That is, we'll see. But
It has to
these
be.
things are in accordance with law. It's all right.
My lord, registration is in accordance with law.
All
But,
right.
my lord,
Yes.
he claims
Sale deed registration is accordance with law.
only no, my lord, the registration process is in accordance with law, but the gift deed, my lord, my lord, it is inherently, my lord, invalid because there's no land, my lord. There's no land at all left. Post 2001, my lord, there is no, I mean, the Kesaragramma ceases to exist.
Eagle sites form ಆಗಿದೆ.
Sites are found. Numerous number of allottees were allotted sites. How could, my lord, they claim that an agricultural land exists?
All
And
right.
in the gift deed as well, why I would say, my lord, this gift deed is fraudulent is that in the gift deed, my lord, he says that he's been paying tax till 2010. To which land, my lord, was he paying taxes? Was it inclusive of the sites, my lord, that are allotted?
Sites are not allotted to him anyway.
My lord,
Yes.
it is allotted to somebody else. my
Yes,
lord.
somebody else.
How could?
No, land is denotified. Denotified, 1 minute.
My lord, they have come up with an explanation.
18/5/1998 denotified. Then how did MUDA form sites and distribute it after denotification? It should vest to the owner.
My lord, they have given explanation, my lord. In the cabinet note, they have given an explanation.
Compensated whom? The landowners.
That is exactly, my lord.
Who is compensated now? Title holder of the day, not the landowners who lost their land then. No, sir, after denotification, it should go back to the landowner, go back to the government. Go back to MUDA rather. Yes. It's gone back to the owner. Owner is that Devraj, is it? Who sold the land to Mallikarjun. Owner is Devraj. The title holder as on the date of the preliminary
He is
notification.
not the owner, my lord.
Then?
No, that is one of the, without going into, that is one of the allegations. Allegation, alala, I'm not the.
No, all right. Yes. Then MUDA formed sites in the agricultural land.
Allegation is not the
Lord.
twofold allegation. Not
Sorry.
No,
So it was mistake of MUDA in forming sites in an agricultural land. So that is why compensation is granted. Hello, who will question?
How would they question, my
Who
lord?
will question?
How would they question?
Hello, it's a personal thing. Why will someone question the gift deed? No, gift deed is purely personal between who is the donor or the donee. That we'll see, yes.
My lord, now, my lord, in connection to the ownership, kindly, my lord, pages 78 may kindly be perused of the writ petition. Page 78, my lord.
Anyway, 1992 owners are Allah.
No,
Owners were different.
not at all. Page 78 may kindly be perused.
Allegation,
my lord.
just one interjection. The allegation is like this. The original owner died. He had 3 sons. Among them, my lords, there was an arrangement by which one person, one Mailaraya, was held the property. But the land is sold by some other person to these persons.
That Devraj or someone.
Devraj, he is,
Lord,
no, no.
in fact,
Mailaraya's name continued. No, these are all allegations. Mailaraya's name continued in the record.
All right.
Right?
Let him finish.
No, I'm just only supplementing what my learned friend is saying.
Yes.
but page 78 may kindly be perused, my lord. Because exactly what I'm trying to put forth, my lord. There are numerous transactions, my lord, in the encumbrance certificate, which are forthcoming. Only Mailaraya's name, my lord, would reflect
Throughout,
throughout.
up to 2003.
Please.
All right. Yes. Anyway, these are on facts.
These are on facts. My lord.
Yes.
I mean,
Mukspuri.
that's not our concern, my lord. We are never getting into
Record.
ownership.
That's
Please.
what. These are on facts. Yes.
Please. Lord, coming back to the gift deed, my lord. Now, in the gift deed, my lord, there were some, my lord, affirmations which are made, that is in connection to possession and tax being paid. How could, my lord, one be in possession of an already developed land by a development authority?
No, it was denotified Andrala.
But physical possession, my lord, remained with the MUDA, and it is still unquestioned. And they, my lord, in the cabinet note, they admit that the compensation is being paid because in the year 2001 itself, MUDA had encroached and they had developed the land
Right.
unintentionally. I mean, that is their affirm, my lord. What they say is that the intimation of denotification was not given to the concerned officer of the MUDA. Therefore, my lord, they were under the impression that the land is still under acquisition and they had, my lord, proceeded. That is their explanation, my lord. It is not my version. Lord, through this gift deed, my lord, in fact, my lord, nothing was sold, my lord, from the beginning, and nothing was purchased, and now nothing is gifted, my lord. Now, based on this nothing, there is something which happens, my lord. On 23/6/2014, my lord. On
23/6,
23/6/2014,
page.
my lord, at page 143, my lord. 143. Lord, this is during the, my lord, in fact, I had to make reference to the cadre, my lord, occupied by the petitioner at the relevant junctures.
Kedaralla, post.
Please. In 1998, my lord, I mean, during the denotification process which happened, he was, it was in the tenure of the petitioner as a deputy chief minister.
1998.
1998.
Uh,
1998.
all right.
Please. And even during the conversion process, my lord, during the spot inspection, order of conversion, even at this juncture, he was the deputy chief minister of the state. Now, my lord, once again, my lord, reverting back to 23/6/2014, my lord, this was during petitioner's tenure as the chief minister. Please. My lord, an application, my lord, for compensation, my lord, is filed by the petitioner's wife, my lord, which is, my lord, forthcoming at page 143, my lord. Now, the interesting
compensation after the gift.
after the gift, 4 years after the lapse of gift. 4 years.
All right.
4 years after the gift. After the lapse of 4 years.
Compensation for what?
Please, my lord. Now I would invite my lordship's kind attention to page 143.
No compensation for MUDA.
Compensation for the very same land, my lord, that is allegedly claimed to have been encroached by the MUDA.
No, the original landowners were not compensated.
No, my lord. No.
All right.
Now, my lord, coming to the last line, my lord, I would not go through the entire record, my lord. ಉದ್ಯಾನವನ್ನು ಅಂತ ಬಂದಿದೆ ನೋಡಿ ಮಾಸ್ ಅಭಿವೃದ್ಧಿ ಪಡಿಸಿ ಪ್ಲೀಸ್ ಪೇಜ್ 143 ಉದ್ಯಾನವನ್ನು ಅಭಿವೃದ್ಧಿಪಡಿಸಿ 2001ರಲ್ಲಿ ಸದರಿ ಬಡಾವಣೆಯಲ್ಲಿ ನಿವೇಶನ ಹಂಚಿಕೆ ಮಾಡಲಾಗಿರುತ್ತದೆ. ದಿಸ್ ಈಸ್ ಅವರ್ ಕ್ಲೇಮ್. My lord, where was Mallikarjunaya in the year 2001? How could conversion, my lord, said to have been done? When in the year 2001, it is her claim, my lord, it is not my claim. It is her letter. It is her affirmation. All right. Now, my lord, in connection to this application, my lord.
So either a role at the time when either the petitioner was deputy chief minister or chief minister, it has happened.
It has happened.
So you attribute this to that.
No, I will come to it.
Yes.
There are few more, Lord, specific allegations. Now on 25/7/2014, my lord, on 25/7/2014, I may take my lords to page 144, my lord, of the writ petition. My lord, 1 month from the date of application, my lord, the earlier application which I referred to,
For compensation.
please, for compensation by the petitioner's wife.
All right.
Now, my lord, there is a proposal, my lord, before the MUDA, that, my lord, the UDD department, my lord, comes to a decision where farmers, my lord, to be compensated at a 50-50 ratio, my lord. Earlier it was 40-60.
All right.
Now, my lord, within, my lord, a short notice, within short time after the filing of application by the petitioner's wife, this decision has been taken, my lord. Now, my lord, I'm not, my lord,
All right.
I'm not completely, my lord, assailing the petitioner in this regard, but, my lord, although it appears public interest, my lord, now the private interest of the petitioner's wife also is taken care of.
All right.
Subsequently, my lord, on 18/8/2014, my lord, now, my lord, MUDA, in response to the application filed by the petitioner's wife, my lord, forthcoming at page 149, my lord.
Seeking, that is 18/8/2014.
Please, 18/8/2014, please,
Commission, it's
please, my lord,
compensation.
please, my lord.
ಅನುಪಾತದಲ್ಲಿ ಅಭಿವೃದ್ಧಿಪಡಿಸಿದ
Please.
ನಿವೇಶನ ಯಜಮಾನ ಬಡಾವಣೆ.
Now, MUDA, my lord, will derive at a market value, or, my lord, it was decided that to give alternative developed sites in a similar layout, my lord, in a 40-60 ratio. My lord, upon which land, my lord, this was computed is the question, my lord, which is still unanswered.
Now this is paid or sites are granted?
Sites are granted. Now, my lord, if my lordship may once again, my lord, refer to page 135, at this juncture, how many sites are granted? It's clearly forthcoming. Near about 20 sites are, my lord, granted thereafter.
Now,
Please, allotted already.
where is the allotment of sites now?
My lord, page 135, my lord.
ಅದು ಹಳೆಯದು allotment.
No, same list, my lord. The list continues till 2009, my lord, in fact.
ಅಲ್ಲ 135 ಅಲ್ಲಿ 19 sites were allotted
Please,
to different people.
to different people
All right.
in the same in the same land in question.
All right.
Please.
Now what is allotted?
No, my lord. At the relevant point of time, there were already. My lord, I'll come there.
All right. Now ಇದೆಲ್ಲ ಆಯ್ತು. Now 60-40 ratio ಅಲ್ಲಿ it was asked. Now land is allotted or not?
Sites are allotted.
Sites are allotted.
Sites are sites are not. I mean, the sites, my lord, in connection to the respective allottees were allotted. Now, what happens with the petitioner's wife, my lord? I will come to it. I will come to it. My lord, now this compensation, my lord, was it, my lord, for the lands occupied by the MUDA in the year 1997, or, my lord, for the lands, my lord, which were already utilized in the year 2001, or, my lord, for the non-existing lands in the year 2004, which was subjected to gift deed, or, my lord, the lands which were subjected to conversion in the year 2005, or a non-existent land which was gifted, my lord, by the petitioner's brother-in-law to the petitioner's wife. My lord, absolutely, my lord. My lord, who is petitioner's wife, my lord, to claim compensation, my lord, is the question, my lord. It's an intriguing question.
No, after the gift, she comes into the shoes of the owner.
I'm sorry, my lord.
No, after the gift
Please.
from brother,
Please.
she becomes the owner of the property.
My lord, how could she, my lord? How could she, my lord? How could she become owner, my lord, of a non-existent land?
That you tell. That's
Please,
all
that is what
right.
that is what I'm trying to put forth, my lord. Lord, in fact, in 2001, my lord, our brother, my lord, he himself was not even in possession of the, my lord, of the land that he claims, my lord.
So he comes into position in 2004.
No, he never comes into possession, my lord, because possession still vests with MUDA till date.
All right.
It still vests with
All
MUDA.
right. On paper, at least comes
On
into
paper,
possession.
on paper. Plain paper was created, my lord, in connection to a non-existent land.
Right, we'll see.
Please.
Hmm.
Thereafter, my lord, 11/2/2015, my lord, page 50, my lord, page 150, page 150. 11/2/2015.
150.
Please, 150. Now, as earlier decided by the MUDA in the year 2014, my lord, I have made a relevant mention regarding the same. Now, this 50-50 Rule 3 was modified, my lord. So as to enable the MUDA to
Right.
hike the compensation.
Aye.
50-50.
Yes.
Even during this tenure, the petitioner was the chief minister.
All right.
Please.
Hmm.
Now, my lord, Again, my lord, automatically, my lord, the illegal claim, my lord, made by the petitioner's wife would, my lord, certainly get enhanced.
Hmm.
Now, coming to the year 2017, my lord, more specifically 15/12/2017 and 30th/12/2017.
Hmm.
My lord, the MUDA council meetings, my lord, wherein, my lord, it was decided, now based on the application, my lord, which I referred to, application seeking compensation. Based on that application, my lord, it was decided in lieu of the acquired land, my lord, it was decided that a parcel of land measuring 13,759 square meters, my lord, would be given as compensation. My lord, shockingly, even after this, my lord, on 25/10/2021, now we'll again come back to 25/10/2021 when the petition, my lord, was the leader of the opposition. 25/10/2021. My lord, another application came to be filed to the MUDA, page 160.
Hmm. For what? For what?
My lord, similar claim, my lord. It was
Alright.
reiteration of the earlier letter. Reiteration of the earlier letter.
So now what has happened? Sites are granted or what?
Lord, now thereafter, it still continues, my lord. There are 2 or 3 junctures, my lord, which I want to put forth.
Me.
Because, my lord, until we dissect, my lord,
Suspense is still going on.
no, until we dissect, this wrongdoing, my lord,
So
cannot
this
be.
is going on till the cows are coming back. Yes,
Please.
tell me.
Lord, on 25/10/2021, a reiteration of the earlier application, Lord. Another application came to be filed on 25/10/2021. Lord, in response to the said application, my lord, MUDA, my lord, dated by order dated 23/11/2021, which may kindly be perused, my lord, at page number 161, my lord.
Hmm.
Please. My lord, in which, my lord, the reference is, my lord, made to the 3 meetings, my lord, on 15/12/2017, 30th/12/2017, and 20th/3/2021. And further reference is made to the 2 applications, my lord.
You are attributing undue influence of the
Absolutely.
office of the chief minister
Office of the Chief Minister.
to
Please.
generate all these things.
Please.
The
please.
foundation is that.
Please.
All right.
Absolutely.
Asked.
Now, my lord, thereafter, my lord, after post 2021, my lord, in response, my lord, in response, on 25/11/2021, my lord, upon direction of the ASLO, my lord, release deed, my lord, came to be executed.
Release date of what?
Release deed of this property,
3.16
property,
acres.
survey number 464.
All right.
That land, my lord, is the subject
Release
matter.
in favor of?
Release in favor of MUDA. Because the decision was taken that we will compensate you, so therefore you
Release
release
in
your.
favor of MUDA.
Please. My lord, all this, my lord, when there was only Devanuru Badavane, when there was only Devanuru Badavane in existence, and Kesare Grama, my lord, ceased to exist long back. When there was a full-fledged layout, my lord, at this juncture, probably from 20 years, my lord, at the relevant juncture. 20 years back itself, my lord, Kesare Grama has been deleted.
All right.
Therefore, my lord, the releasing the title and ownership of a non-existent land, my lord, which I would say. My lord, on 5/1/2022, now the culmination of all this, my lord, allotment letters, my lord, for 14, my lord, 14 compensatory sites came to be allocated. 14 compensatory sites,
Illig Bunny.
which is forthcoming at page number 178 to 194. Individual allotment letters to various sites. Lord, interestingly,
Individual allotment letters in favor of.
petitioner's wife. Petitioner's wife.
All right. That's 176. Page 176.
178, my lord. 178. 178.
Oh, these are allotment letters. is it?
These are allotment letters.
All right. Amala.
Lord, one interesting aspect, my lord, which my lords must observe. In the allotment letter, my lord, in the allotment letter, a reference has been made to meeting that was held on 20th/10/2020.
20th November.
20th/11/2020.
Hmm.
Please. In the fourth line, my lord,
Yes.
please.
Hmm.
Now, my lord, the ALSO in his direction, my lord,
Yes,
the
sir.
ASLO in his direction, he never, my lord, when he directs the petitioner's wife to relinquish the rights over the land in question, he never, my lord, makes reference to this meeting, my lord. All of a sudden, my lord, this is now parachuted into the
Parachuted.
allotment letter.
Parachuted.
Out of nowhere it has come, my lord.
Yes.
Out of nowhere.
Ah.
It is parachute.
Hmm.
My lord, another, my lord, interesting aspect, my lord. My lord, at page 159, my lord, if my lords may kindly peruse, during the MUDA meeting, my lord, during the MUDA meeting held on 20th/3/2021, I'm sorry, my lord, I had missed on an aspect which I should
No
draw
problem.
my lord's kind attention to.
We're going here and there, it's all right.
In this very meeting, my lord, the petitioner's son, my lord, he was also part of the meeting in his capacity.
Now, where did the son come from?
He appears here, my lord. He
You
appears
were-
here. Please. Kindly, my lord, page 159 may kindly be perused. Ink page 159, serial number 10.
10 na?
Serial number 10.
Ah,
Hajaridda Sadasyaru. Page 159, my lord.
all right.
Please.
As an MLA sitting there.
He was an MLA then?
He was an MLA, my lord, but the cabinet's reply to the same, my lord, is in fact, I will come to it.
They knew that they were filing a complaint, you would not have been there.
No, in connection to the presence of the petitioner's son, my lord. I will come to
All right. ಈಗ ಅದಾದ್ಮೇಲೆ ಇದು ಮುಗಿಸ್ಬಿಡಿ ಇದು.
Please,
Ah.
please.
Because all this while I was under the impression only the wife of the chief minister was there. You are bringing the son also now.
My lord, he is the part of two meetings held by the MUDA. Held by the MUDA. No,
ಬೇರೆಯವರು
sir,
ಇದ್ದಾರಾ?
I may kindly be permitted to complete.
ಅದ್ರಲ್ಲಿ ಬೇರೆಯವರು ಇದ್ದಾರೆ. ಹಾ.
Others idare. But their reply, my lord, in their reply they state that he is only present and he has not participated in any of the
He
meetings.
is there.
That is their reply. My lord, on two occasions, my lord, he is present, which is when the said application, my lord, was placed before the MUDA, my lord.
All right.
The two occasions are 20th/11/2020, which is, my lord, forthcoming at page 304, page 304,
Hmm.
and 20th/3/2021, which I referred to some time back.
ಇವೆಲ್ಲ ಒಂದು
I
written
will-
submission ತರ
I will hand it
ಕೊಡ್ಬೇಕು.
over. Please. Therefore, my lord, to conclude, my lord, in connection to the allegations, my lord, a non-existent land, my lord, was subjected to a sale deed. A non-existent land was subjected to conversion. Thereafter, a non-existent land also came to be gifted, which my lord, I earlier called it Wonderland.
All right.
Then subsequently, my lord, compensation was claimed for losing nothing.
Like 14 sites ಆದ್ಮೇಲೆ ಏನಾಯ್ತು? Relinquish ಮಾಡಿ.
She has received the sites.
Compensation is
She has
granted?
received the sites.
No. The sites are received now.
14 sites are the compensation.
Now 14 sites are in possession of the wife of chief minister.
Till date, as admitted by the petitioner. And that 55 crores, my lord, I mean,
What is the value of those 14 sites?
that is the value of those 14 sites. It's my computation, my lord. Now, the petitioner, my lord, I mean, off the record, my lord, if I may say, the petitioner comes to the news media and he says, it's worth 62 crores.
All
And
right.
he says,
Somewhere there.
And he says, compensate me with rupees 62 crores. I will return these sites. That is what he says on the news media.
All right.
Right.
Ashana,
Lord, now coming to the,
it's still coming.
the gist is over.
Yes.
I am done with the gist.
Yes.
Now, my lord, whether
Hmm.
sanction is warranted in my case.
Approval.
Approval and sanction. Approval
Sanction
and
2 and 8, that stage has not yet come.
Please. My lord, I will confine myself to 17 name. I would not, my lord, delve into the technicalities of section 2 and 8 of BNSS. My lord, I would say that sanction, my lord, in my case is not applicable on two folds. Firstly, my lord, the offenses, my lord, the most part of the sequential offense is, my lord, committed prior, my lord, to the insertion of section 17A into the Prevention of Corruption. That being the case, my lord, now as per the dictum, my lord, laid down in Tejmal Chaudhary's
All
case,
right.
which I would, my lord, refer to. Madam. Yes. Illi. Is it Tejmal Chaudhary? Lord, at page 204 of the compilation, my lord.
ಅವ್ರು ಕೊಟ್ಟಿದ್ದೀರಾ ಕಾಪಿ?
It's given, my lord. I served this offer.
204.
204. No, sir, I haven't. I don't have it. No, I mean, I have received the hard copies today, sir. Lord, I would, my lord, first go through with the keynotes, please. Page 204. 2022 live law SC 1. SC 198. 158. 158. If I may.
ಹೆಸರು ರಂಗನಾಥ್ ಅಲ್ಲ?
Please.
ಸಿ ಪ್ಯಾರಾ 6. ಅಷ್ಟು ಓದ್ಬಿಟ್ಟು ಮುಂದೆ ಬರಿಬೇಕಾ ನೋಡಿ.
Lord,
ಅಷ್ಟು ಓದ್ಬಿಟ್ಟು ಮುಂದೆ ಬರಿಬೇಕಾ ನೋಡಿ.
please, my lord, I will
Read.
please. In this case,
Read it loud.
the FIR was filed on 1/1/2018. Before
Stop
this,
there. FIR was filed on 1/1/2008
filed.
prior to the provision coming into force. The provision comes into force on 26/7/2018.
Lord, para,
ಅಲ್ಲಿದೆ, ಅದೇ ಡೇಟ್ ಇದೆ ನೋಡಿ. 26/7/2008. If the FIR is filed prior to the act coming into force, it is obvious that it should the act would not, the 17A would not become applicable. Here FIR is registered. FIR is not yet registered, but
not
the
yet registered.
Sir, incidents may have taken place 100 years ago, 50 years ago, 10 years ago, but 17A is in place today. You are registering the crime today. 17A would be applicable. This is a case where FIR had already been registered. You cannot give retrospective effect to 17A and say already registered FIRs also will have to pass muster 17A. ಅಷ್ಟೇ ಅದ್ರಲ್ಲಿ.
Not the apex court says offences which existed prior, my lord.
Sir, offenses ಅಂದ್ರೆ ಏನು?
Lord,
What do you mean
mere-
offenses under not in the imaginary kind of offenses? Offenses that are depicted in a crime. That is on 1/1/2018 FIR is registered. That is why Supreme Court wrote 17A would not have retrospective effect for FIRs already registered. New incident, see, something would have happened in 2015. 17A is not applicable. You want to bring up that incident of 2015 in 2020. And seek to register a crime against a public servant. You're registering today. Incident may have happened, then it's not post facto law concept iduk baralla.
Lord,
But that is the judgment there. ನೀವು ಅವತ್ತೇ ಕೊಟ್ರಿ ನನಗೆ ಇದನ್ನ.
I've taken
I
this
was also
contention,
surprised.
Lord, it's for my lords to.
Incidents, see, I will write, that's a different
Please,
thing.
my lord.
But
No, my lord, this is not the only ground, my lord, which I'm
no, I'm
asking.
not saying that. I'm not telling you that you're wrong also. I'll have to apply my mind on that. That's a different
Please,
thing.
please.
But this judgment, FIR was already in place. ನೀವು ಅದನ್ನ ನೋಡ್ಬೇಕು first.
Certainly, my lord. I
Facts
mean,
and
I'm not
then law.
disputing the fact, my lord.
Yes.
But since, my lord, offenses, my lord, in crude meaning, my lord, offenses, my lord, the offense existed prior to the insertion.
Sir,
As per the allegation.
offense may have existed. It comes into light
Please.
in a particular
No,
way.
I would, my lord.
See, you may project delay.
Please.
That's a different.
Please.
Whoever the accused may project delay in registering the crime. But 17A applicability, retrospectivity, definitely.
Please. My lord, I would oblige to my lord's view on this. But
That-
anyway,
that
the
the Supreme Court
contention
has
was
written,
taken.
we'll consider.
Please, please,
Yes. This
No, my lord.
judgment went on that footing that FIR was already registered on 1/1/2008.
please. Lord, whether to the allegations, my lord, forthcoming in the my lord, instant case, whether 17A would be warranted.
That you tell.
Please.
Yes.
Lord, I invite my Lordship's kind attention to page 191, my Lord, rendered by the Kerala High Court, wherein reference was made to many other High Court judgments, my Lord. Page 191, my Lord.
191 of your compilation.
191 of my citation compilation.
191 is it?
191.
ಒನ್ 191 ಯಾವ್ದೋ ಮಧ್ಯದಲ್ಲಿದೆ ರಂಗನಾಥ್.
TO Suraj versus State.
ಹಾ,
Not 148.
148.
148.
What is the ratio here?
Lord, paragraph 13, my Lord, page 13, paragraph 13, my Lord.
Page 13.
Page 13, paragraph 13,
All right.
please. The expression anta shuruvagate mass.
Yes.
The expression discharge of his official functions or duties in section 17A of the Act reflects the legislative intent that the protection envisaged is not a blanket protection.
All right, 17 ಬೇಕಾಗಿಲ್ಲ ಅಂತ ನೀವು ಹೇಳ್ತೀರಾ.
Bekagilla. This is not, my Lord, in connection to the decision taken or recommendation made by the petitioner. My Lord, in connection to the same, my Lord, your Lordship may kindly peruse page 43, my Lord, 43 and 44, my Lord. I would straight away draw my Lordship's kind attention to para 55.
Against
forthcoming
whom are you complaining now?
against the petitioner, his wife, and the officials, my Lord.
And you just now said that it is undue influence
And you,
of the chief minister
please,
in the when holding office
please,
that he has done all this,
please.
is what you said.
Absolutely.
So ಅದಕ್ಕೆ 17 ಬೇಕಾಗಲ್ಲ.
Bekagalla.
All right. We can-
Because it is not in recommendation or, my Lord, or in any manner, my Lord, it is not in discharge of his official duty.
All right.
My Lord, the same, my Lord, had been reiterated in other authorities, my Lord, which are forthcoming at paragraph 55, my Lord. 55, the authority rendered by the Honorable Delhi High Court, and 56, my Lord, which is in conformity, my Lord, by the Honorable Chhattisgarh High Court, and 57, my Lord, which is on the similar lines, my Lord, rendered by the Honorable Madras High Court.
ನೀವು ನೋಟ್ ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ.
I'll file it, please.
ಆಲ್ ನಿಮ್ ಜಡ್ಮೆಂಟ್ಸ್ ರಂಗನಾಥ್ ಜಡ್ಮೆಂಟ್ಸ್ ಯಾವ್ದ್ರಲ್ಲಿ ಆಗಿದೆ?
Please, along with the extractions, I will furnish.
like how the others have done.
Please, I will file,
Same manner.
along with the extractions, I will file it.
ಇನ್ನ ಏನಿದೆ?
My Lord, in connection to, my Lord, whether it is a relevant stage, my Lord, to obtain sanction under section 218, my Lord. Of
Sanction is not the stage at all.
Not at this stage, my Lord, although, I mean, it's.
ಅಲ್ಲ ಅಲ್ಲಿ ಹೇಳಿದಾರೆ ಅಷ್ಟೇ. Sanction
ಹೇಳಿದ್ದಾರೆ.
is not in that stage at all. It is post investigation.
That is what, my Lord, I
That
wanted
you
to
need
clarify.
not-
my
you
Lord.
need not
Because
labor on
Manju Surana's case, my Lord, is
So you need not labor on that. No, Manju Surana's case, whether
section 19.
156(3) ಗೆ ರೆಫರ್ ಮಾಡಬೇಕಾದ್ರೆ ಸ್ಯಾಂಕ್ಷನ್ ಬೇಕೋ ಬೇಡವೋ
Absolutely.
ಅಂತ. That is now referred to a larger bench.
Please,
That larger bench is being constituted now. That's all right.
Lord, about
That
3
is,
months
that is
back.
what was said in MK Ayyappa.
Please.
That was doubted in Manju Surana and
Manju Surana.
referred to a
Lord,
larger
in fact,
bench.
my Lord, recently, my Lord,
That is what now the court has directed it to be constituted immediately.
my Lord, very recent dictum, my Lord, in this
ಗವಾಯಿ
regard.
ಅವ್ರದ್ದು ಇರ್ಬೇಕು.
Madam.
ಆಗೋಗಿದ್ಯಾ ಜಡ್ಮೆಂಟ್?
No, my Lord, not Manju Surana. This is also, my Lord, referred to Manju Surana, but this is the recent dictum, my Lord. What they have expressed, my Lord, in this regard.
It was referred to a larger bench on 27/3/2018.
Please, my Lord. Now, this is of the year 2024, my Lord.
ಅಲ್ಲ ಅದು ಗೊತ್ತು ಹೇಳಿದ್ದು.
Please. No, they have just,
156(3) ಗೆ ಸ್ಯಾಂಕ್ಷನ್ ಬೇಕಾ ಬೇಡವಾ ಅಂತ.
they have formed an opinion, my Lord, at page 3, my Lord. Although the division bench.
Again, I'll tell you one thing.
Please.
ಈ 156(3) ಗೆ ಸ್ಯಾಂಕ್ಷನ್ ಬೇಕೋ ಬೇಡವೋ ಅಂತ, that was found to be necessary at the stage when 17A was not in the statute.
Please. Absolutely, my Lord.
So that is why the matter was referred. Now 17A itself acts as that protective layer of sanction,
Further.
whether required for 156(3) or
Please,
not. This, that's
Because
what,
Ayappa, my lord,
MK Ayappa was 2012, sir.
was at the teeth of
Yeah.
my lord R.R. Chari.
Yes,
So therefore,
because that's
three
2012.
judgments. Yes, yes, my lord. So, my lord, recently also, my lord, before my lord ordering to
Now
place-
that is why 17A takes care of 156.3 at the stage of, takes care of sanction at the stage of 156.3.
please. My lord, now, my lord, in this connection, I would just read the relevant portion, but I will conclude with this. My lord, we are of the considered opinion, considered view that scanning of the provisions under section 156 subclass 3, 173 subclass 2, 190, 200, 202, 203 and 204 of the CRPC would prima facie reveal that while directing for an investigation and forwarding the complaint thereof, the magistrate is not actually taking cognizance. However, since the said question is referred as per the above judgment, judicial discipline and propriety dissuade us from proceeding further with the case, and hence we order to tag the caption matters along with Manju Surana. But because this will be the next contention.
No.
After, if at all, madam,
All those were rendered in a scenario where 17A was not there.
because before this Giants case was, my lord, rendered by the Honorable Apex Court. So therefore, my lord, these are the recent, my lord, views
Whether
taken by the-
Manjusurana comes out or not, or what is written, 17A is already in statute.
we do not know, my lord.
That's
Because,
it.
because the respondent number 3's petition, my lord, which was challenged before the Honorable Apex Court, TJ Abraham versus Yedurappa. I mean, that, my lord, now it may be tagged along with Manju
Phone
Surana.
number 3 and
TJ Abraham.
oh, that's the.
Please.
Yes.
It was, my lord, the reported dictum of this Honorable Court, which is now under challenge, my lord. Probably these are all these, my lord, the questions would
No,
be answered.
that's what I feel in sense. 17A ಇದೆಯಲ್ಲ ಅದಕ್ಕೆ ಅಂತ.
Please. So 17A, my lord,
ಅದೆಲ್ಲ ಹೇಳಿದ್ದಾರೆ ಬಿಡಿ.
please. So therefore, my lord, 17A.
Application of mind and other things of the governor you need not labor because the
No, my lord, I would limit
Solicitor
myself.
General himself has told.
Lord, I would limit myself, my lord. Since non-issuance of show cause notice, my lord, is made out as against the other respondents, certainly I am immune to that ground, my lord, because in my case, show cause notice was
It's
issued.
already issued, so you
Because
need not
notice was
labor on
issued.
others ground.
Please. Lord, the Honorable Governor, my lord, certainly has followed due process in my case, my lord.
Decathlon, 60 plus sports, 6,000 plus products. Decathlon. Visit the store or download the app.